Hello, my name's Gregory Brown. I'm a business litigation attorney and trial specialist with the law firm of Brown and Charbonneau. Today, we're going to talk about whether to settle your business litigation case or have your day in court. Most business litigation ends with a settlement. Often, the earlier you can settle, the greater the economic benefit. Settlement may provide benefits not available through litigation. For example, one party might offer business concessions to the other, even on issues not involved in the litigation. The parties could agree that the settlement will be paid over time, with collateral to secure the payment. As the case progresses, you and your attorney should conduct an ongoing risk-benefit analysis. This analysis, coupled with proper timing of settlement overtures, can be the key to a favorable outcome, whether you're the plaintiff or the defendant. Here are 6 factors to consider in conducting your cost-benefit analysis. Number 1, time demands. Litigation takes significant time away from your business operations. Some time-consuming tasks include finding relevant documents and responding to discovery, communicating with your attorneys, training your employees to support the litigation process, and making them available for deposition and trial. Number 2, litigation expenses. Costs mount dramatically as litigation proceeds. Experts must be paid. Court costs, travel expenses, witness fees, and other incidental charges are incurred. Attorney's fees can mount as well. Now, sometimes plaintiff attorneys would work on a contingency basis, and they'll generally take a third of the recovery. But at trial, they may take as much as 50%. If attorneys are billing hourly, the longer the litigation continues, obviously the higher the fees. Okay, number 3, strength of the claims and defenses. Evidence that puts the case in a different light may emerge from discovery and even testimony before or at trial. A plaintiff's claims or a defendant's defenses and counterclaims may be stronger or weaker than they initially appeared. Now, number 4, the amount at issue and the likelihood of collecting. Now, if a plaintiff knows its damages are minimal, or the defendant lacks insurance or other means to pay, taking the case to trial may not make economic sense. Number 5, damages to your business's reputation. Aside from legal liability, a business needs to keep its reputation in mind. A negative perception can affect revenue. If a company sues a long-standing client for a default that it could have resolved with a business resolution, others may notice and take their business elsewhere. Number 6, preservation of business relationships. A lawsuit can damage or destroy a profitable business relationship. An early settlement may be preferable to jeopardizing future revenue and relationships. When are settlement overtures most likely to be fruitful? Sometimes when business disputes are more likely to settle are, number 1, before or shortly after a lawsuit is filed. These are typically cases in which the defendant's liability is clear and the damages are modest. Alternatively, one or both parties may be eager to preserve their business relationship. If the defendant has insurance, the insurance adjuster may be willing to settle quickly. Number 2, before the discovery process begins, settlement will avoid the considerable expense and time investment of answering interrogatories, locating and producing documents, and taking or attending depositions. Number 3, after the discovery process concludes, when each side has a good idea of the other's evidence and the attorneys can make an educated prediction about the outcome of a trial. Number 4, even on the eve of trial, when facing the last chance to avoid the expenses and risks of trying the case before a jury. Though most cases settle before trial, settlement during or even after trial is possible. For example, number 5, after the plaintiff presents a strong case, when the defense anticipates a large verdict in the plaintiff's favor. Number 6, after a verdict, to avoid the delay, expense, and uncertainty of an appeal. Now, most cases come down to a question of how much one side will pay and the other side will accept to avoid the risks of litigation. Some cases, however, may be worth pursuing to trial simply to cure an injustice or for other business strategic reasons. Although you may be initially eager for your day in court, you will make better decisions if you view your case objectively, as a juror would, rather than as someone personally embroiled in the issue. For more information on this topic or any other business disputes, call us today at 714-505-3000 or email us at inquiries@bc-llp.com.